Wonderful. Well, hello everyone. Thank you for joining us this evening. My name is Wilson Green, and joining me is Regina Chavis. Both Regina and I are fellows with the Disaster Relief Project at Legal Aid of North Carolina. And if you don't already know, Legal Aid of North Carolina is a statewide nonprofit organization that provides free legal services for certain civil matters. And in particular, the disaster relief team, which Regina and I are on, provides legal assistance and education to survivors of natural disasters in North Carolina and supports community economic development and long-term recovery in disaster impacted communities. And there's on the slide just a few things that we do on the disaster relief team. And these days, most of our work kind of revolves around assisting clients with applying for federal, state, and nonprofit disaster relief programs that, for example, might help repair or replace homes that were damaged by hurricanes. And related to that, this evening, Regina and I will be briefly discussing an ownership issue that commonly affects some of our clients who apply for these types of programs. But before we start, I'll just quickly mention that this presentation is not intended to be legal advice. Regina and I are not your attorneys. Instead, this is more just a general overview of a kind of a single legal issue that we encounter often, in the hopes that it provides some enlightenment to you and maybe understanding your own situation. But if you are watching or watching in the future and you have a specific legal question or wish to receive legal assistance with maybe a situation that you're in regarding disaster recovery, we just ask that you reach out to the Legal Aid Helpline. The number is listed below. It's 1-866-219-5262. And hopefully by calling that number, you can receive help with your specific legal question or possibly your case. So this evening, we will be talking about the concept of heir property and how this issue might affect your ability to receive disaster relief assistance. So when we help clients who are homeowners seeking repair or replacement of their homes, the federal, state, and nonprofit relief programs that we typically help clients apply for usually have several eligibility requirements relating to ownership. So first and foremost, maybe the more obvious one is that I would say all of these programs require homeowners to provide some kind of proof that they own the property in question, the damaged property. So this might be a deed to the land or the home that you live in. If it's a mobile home, it might be a title that would be provided by the DMV. In addition to proving ownership, in cases where you might own a home with several people, maybe several family members, and you're seeking to have that home replaced or repaired, most of these programs would require you to get consent from the other owners, consent to allow the home to be repaired or replaced. And because of these two broad requirements, proving ownership and in some cases getting consent from other possible owners, we have found that one common barrier some of our clients face is that they own what is called heir property, what we're going to talk about tonight. Many of you might have heard this term before. Kind of a basic general definition is heir property is a home or land that passes without a will from one generation to another, resulting in ownership that is divided among different living descendants of a family. So in some cases, our clients who own heir property run into issues because it can be unclear who exactly owns the property in question. So it can be difficult to get consent from those people. and in other cases, it can be difficult to even prove that you own the property because you inherited it. Maybe a deed was never passed to you. A will never said that you were to receive the property. Because this is a common issue in this context of proving ownership, I'm going to give kind of a brief but a little more in-depth overview of what heir property is, so that if you're watching, you might be able to determine if this describes your own situation. I'll go through some definitions, cover heir property, and then also touch on what really doesn't matter when proving ownership in heir property. And then my colleague Regina is going to kind of show how you might determine who the heirs are to a certain property that you own or live on, and how you might do that and how that might help speed along the process of maybe getting disaster relief. So first, I'm just going to go through a couple quick important definitions. And the first one being a will. I imagine most of you probably know what a will is, but just in case, a will is a legal document containing instructions as to what should be done with your property, your money, your possessions, your home, after one's death, after your death. With that said, there's several specific requirements that a will must comply with under North Carolina law to be considered valid. That's kind of beyond the scope of this presentation, but I'll just note that it's important to remember that if you're considering making a will to possibly avoid the issue that we're going to be talking about, heir property, it's important that you consider contacting a lawyer or consider contacting a legal aid attorney at the number that we provided above. These requirements are pretty specific, and typically it's best to have an attorney involved if possible. The next term is intestate, which simply describes a person who has died without having made a will prior to their death. And then the next term being kind of the opposite, testate, a person who has died, who did leave a will, a valid will prior to dying. And then under these two terms come those who receive property. So the first being a beneficiary, which would be a person who is named in a will, who benefits from that will. So for example, say you create a will where you give some property to your daughter, Deborah. Then under your will, your daughter, Deborah, is a beneficiary of the will. And then on the other hand is an heir. This kind of relates to intestate, like in the way that beneficiary relates to testate. An heir, at least at the legal definition of an heir, is an individual who is legally entitled to inherit the money or property or possessions of another person who dies intestate, a person who dies without a will. And lastly, decedent. Decedent is simply just a fancy word for describing someone who has died. Whether that person has died with or without a will, the person who died having some property is referred to as the decedent. So putting all this together, using these kind of general definitions, we can essentially frame the concept of heir property. When someone dies testate, someone who dies with a will, the will controls who the property passes to. I would imagine most of us know that. So if you write in your will that you want all of your worldly possessions to pass to your brother, Bob, then upon your death, in most circumstances, the will controls and all of your possessions will pass to your brother, Bob, once that will is probated. But on the other hand, when someone dies intestate, that is without a will, then his or her property passes according to what is called the North Carolina Intestate Succession Act. These are sometimes, this law is referred to as kind of the default rule or a law that provides default rules. Whereas when you die without a will, instead of your property passing according to your wishes that would maybe laid out in a will, instead your property passes to your heirs according to this law, this Intestate Succession Act. Hence the term heir property. And many examples can be kind of formulated to explain how property is passed to different heirs. And Regina is going to kind of explain this in more depth. But before I kind of before she explains these specific examples, I'll just quickly say a couple of quick things. First, this heir property issue can really create problems for disaster relief purposes. So as I mentioned, the Intestate Succession Act controls how property is transferred upon the death of someone who dies without a will. All of the heirs who inherit the property, according to this law, are all given co-ownership of the property. So then, if those folks, those heirs, when and if they pass away, and if they pass away without a will, then again, ownership is divided among their heirs. So it can go through several generations of heirs over time if folks are passing away without wills. And so you can imagine situations over time that a single piece of property, a single home, can be kind of fractionated. It can be owned by a lot of different people. And so in our team and many of our attorneys and paralegals and the people that work for us, what we see often is that property might be owned by dozens of people. Maybe even in some cases, I've seen cases where over 100 people own a single property. And so you can imagine, practically speaking, in a situation where you might need to get the consent from all of the owners of a property to receive disaster assistance, it could be quite difficult to maybe track down dozens of people, 50 people, to get their permission for a home to be repaired or replaced. Also, when property is inherited without a will, so there's not kind of a document saying where property should go, it can be kind of difficult at times and cumbersome to prove that you're one of the heirs, to prove that you're one of the owners. It can be a process that requires an attorney, and it requires a little bit of effort. And then on the other hand, since heirs become owners of property kind of through law, and their heirs are determined by law, there are certain facts that don't really matter when it comes to proving ownership of heir property. In other words, once someone owns property as an heir, their ownership is pretty much conclusive at law. So as a couple of examples of things that don't matter and some common misconceptions, when you own heir property with many other people or with several other heirs, the fact that you're the only heir that actually lives on the property, or maybe in the house in question, that's pretty much irrelevant for proving ownership. It doesn't mean that you have some kind of superior ownership interest over the other heirs just because you live in that home. And in a similar vein, say there are many heirs who own a house or own property. The fact that you might not know who they are, you've never met them, you don't even know, you're not sure they exist, that doesn't mean that you're the only owner or that they don't exist in the first place. Or maybe there's a situation where 20 other people who co-own this property with you as heirs. The fact that you might know that they have told you in the past, I don't care about this property, or you own this property, I don't care about this property, that doesn't change the ownership scenario. They still own that property legally, even if they've said to you that they don't care about it or they don't want it. And as I've already hinted at, the mere desires or wishes of the last person to have lived on the property or in the house, or maybe the last person listed on the deed, that's also irrelevant for ownership purposes. So for example, if your sister was the last person listed on a deed, or maybe the last person to live in a home, and a home that she owned by herself, she was the sole owner. If she told you maybe on her deathbed in front of the entire family that she wanted the property to go to you, But she didn't write that in a will. That wasn't documented in any kind of valid will under North Carolina law. The fact that she told you what she wanted, and she told the whole family, that still doesn't matter. The North Carolina laws, the default rules still kick in, and the heirs are determined by a law, and that property will pass intestate because there was no will, and it'll pass to certain people as determined by law, as Regina will explain. And then lastly, in most cases, just because you pay bills on the land or on the home, like property taxes, that doesn't mean that you have some kind of superior ownership interest over other heirs if it is heir property. It's worth noting there's one like kind of small exception or exception that plays in this case with FEMA. In some cases, FEMA will allow applicants to prove ownership by providing a property tax bill. But just because you are one of several heirs and you pay the property taxes, or you pay the light bill, or you pay some kind of bill on the property, that doesn't give you some kind of superior ownership interest. With all this said, however, just because you own heir property, you live on heir property, you own it with a lot of other folks, this does not mean that you are excluded from receiving disaster relief assistance. It just means that the process might be a little slower. It might mean it's a little more complicated. It might mean that you really need help, that you need an attorney to come help you. And that's why we've provided the legal aid helpline number at the beginning, and we'll provide it again at the end. But in the meantime, if this is kind of describing your situation, one thing you can begin thinking about, and one thing you can begin doing, is figuring out who are the heirs that own this property? Who are the other folks, if you don't already know? And this will help you begin clarify what needs to happen for you to get disaster relief. And so with that said, Regina Chavis is going to kind of explain how you can begin clarifying who the other heirs are by kind of formulating a family tree and using that to understand how North Carolina law determines heirs.
Thank you, Wilson. So as Wilson has said, many of our clients who have been affected by the recent storms are heir property owners. A lot of homeowners in the affected areas are heir property owners. So we're just talking about some of the issues that we see, and we hope that this video helps you to determine if you have an heir property ownership issue and just the steps to take to go about learning who your heirs are, determining who your heirs are. So the first thing to understand is that often we use the term heirs very loosely, but according to the law, heirs are determined by law, and heirs are determined after death. So you are not an heir to someone's property, or you don't have heirs by law. You don't have heirs by law until you die. So the heirs of property are determined after the death of a person. Wilson, you can go to the next slide, please. So I have a few examples of some basic scenarios of when a person dies without a will, just to look at how to begin to formulate a family tree. So this is Bill. Bill is going to be used in all of our examples, and Bill died intestate, which means that Bill died without a will. So we must determine who are Bill's heirs. Okay, next slide. So if Bill died without a will, he died intestate, when there's only a surviving spouse, then the spouse is the only heir. So that means when Bill died, he had no child, he had no descendants of deceased children, so no grandchildren or great-grandchildren, and he had no parents, but he had a surviving spouse, then that spouse is Bill's heir. Even if Bill and his spouse have been separated for years, that spouse is his heir. and that spouse has a right or an interest to Bill's property. So if Bill owns heir property and Bill owns heir property with his siblings, then when Bill dies, if there was never a will put in place, then now the siblings own with the wife, who Bill may not have spoken to for years. So if there is a surviving spouse, if there is a spouse, even if they have been separated for years, that spouse can be an heir. That's a situation that we run into often. Wilson, can you go to the next slide? Okay, so Bill dies intestate. Bill dies without a will. If Bill dies and there is a spouse and a child, and the child includes descendants of a deceased child. So if there was a spouse and there was one child, or any descendants of the deceased child, then they are the heirs. So the spouse and the child, or the spouse and the descendants of the child, are Bill's heirs. And so the property will be split between those two. Okay, Wilson, you can go to the next slide. When there's a surviving spouse and 2 or more children, then, and Bill dies without a will, Bill dies intestate, then the surviving spouse and the children, or the descendants of the children, are the heirs. So if any children have died, but they have descendants who are living, then those descendants are the heirs. Okay, next slide. Now, it gets a little bit more complicated, and these are some of the things that we found that people aren't really aware of. When there's a surviving spouse, so Bill dies without a will, and there's a surviving spouse, there are no children, there are no descendants of children, but Bill has 1 or more parents, then the spouse and the parents are Bill's heirs. So this is something that many spouses may not understand, but the spouse and the parents become the heirs of Bill. And when we think of heirs, we think of people under us. That's why we have to really look at the legal definition. So legally, heirs aren't determined until you die. And so if there was a spouse and children, the parent would not be heirs. But because there are no children and no grandchildren, but there's a spouse, if there's a spouse and parents, then the spouse and the parents are the heirs. Next slide. So when there is, Bill dies intestate, Bill dies without a will, and there are no, there is no spouse, there are no children or descendants of children, and there are no parents, then Bill's siblings and the descendants of any deceased siblings become the heirs. So this happens by law. It does not matter if you don't like one of your siblings. It does not matter if one of your siblings would not be good with property ownership. It does not matter if you love one of your siblings the most. The property is equally divided by your siblings. And if any of your siblings happen to be deceased, then their portion would pass to their lineal descendants. So that may mean that your nieces or nephews may become your heirs. So this, like we said, this is, and Wilson mentioned it earlier, when you write a will, then you are able to say or determine who you want to receive your property. So when there is no will, you cannot determine, you know, who gets your property. And so it could be that it goes to the brother that you don't really care for, but you didn't write a will, you didn't have a will. So your property, your siblings could end up being your heirs. Wilson, next slide. So and Wilson talked about this, spoke about this earlier, as people die without wills and when you have heir property, you may start with a few owners, 2 owners, 4 owners, but as more and more people die and you have more and more generations of people, then the owners increase. And so you have, a lot more owners. And so the way that affects disaster relief is when you have to show ownership, a lot of times you have to go back and trace and do a family tree to find out who do you own with. And you may own with a brother, you may own with your brother's wife, you may own with a lot of different people that you don't realize are also heirs to the property. Wilson, can you go to the next slide? So when you're determining if someone is your heir, remember this is not determined until after death. So when Bill dies, and Bill dies without a will, when we're looking at who are Bill's heirs, a half sibling might be Bill's heir. A deadbeat parent might be Bill's heir. An in-law may become Bill's heir. A non-relative may even become Bill's heir. So it's very important that when you have heir property, you determine who your heirs are, or you try to determine who your heirs are, or you create a will so that you can determine where your property goes. Next slide. We thank you very much for joining this presentation. And if you have any questions, we have the the web address, on the screen. You can go to this address and find information. We also have the phone number. So if you want more information or you need to talk to an attorney about your property and you have questions, you may also call this number to get more information. We hope that this presentation was helpful for you, and we hope that you're thinking about who are your heirs. Have a good day.